What I like in the case ANTARIS versus Czech Republic is the fact that the investor has succeeded in convincing the ICSID tribunal that the solar levy, which is a tax under the Czech law, is not a tax under the international investment law. This is a wonderful thing. The Energy Charter Treaty makes an exception for the fair and equitable treatment principle. It says that taxation measures are accepted. And then in order to get back under the protection of the fair and equitable treatment, the investor has to prove that the measure is not a taxation, it is not a tax, it is not for the purpose of increasing the state's incomes. It is for some other purpose. And basically, ANTARIS did the same thing as UCOS did in their case against Russia. UCOS had brought a statement at a press conference from Vladimir Putin that became an evidence that, in fact, this taxation proceedings had been for other purposes. In the same manner, ANTARIS brings minutes of a coordination committee under the Ministry of Industry and Trade. And in that meeting, we have two statements from two officials, one of whom is the Deputy Minister of Environment. Both of them recognize that the solar levy should be introduced in the Czech Republic in order to reduce the incomes of the solar energy producers receiving subsidies from the state. This is the reason why they decided to introduce the solar levy. So this is not a tax, this is not a purpose of increasing the incomes of the state, but rather it has a purpose of reducing the subsidies to producers of solar energy. So ANTARIS won the case on the jurisdiction question, but then unfortunately they lost at the merits stage. So the ICSID tribunal has decided that the measure, which is not a tax, is still rational, reasonable, and fair. So there was no breach of the fair and equitable treatment standard.